The California Code of Regulations codifies or establishes the laws and rules for the ethical codes of conduct for alcohol and drug counselors. Now, it's important to note that the state code of regulations sets the minimum ethical codes for conduct, and then it defers to the certifying organizations to expand or develop the ethical codes beyond the minimum state requirements. In Title IX, Section 13060, this is the key section for the state minimum ethical codes of conduct. The entire section addresses those standards and requirements for drug and alcohol counselors. In the very first sentence in the first section, it states, quote, each certifying organization shall require registrants and certified AOD counselors to comply with a code of conduct developed by the certifying organization in compliance with the requirements of this registration. Now, that's a bit of legal speak there. What that sentence essentially means is that the state is telling the certifying organizations that they need to develop a code of ethical conduct for both registered and certified counselors, and that the state will provide them with the minimum requirements to include in those codes. Now, the highlights from the state's minimum ethical requirements for drug and alcohol counselors will be included in the next number of slides. So the first one, in section B2, it states that drug and alcohol counselors must protect the client rights to confidentiality in accordance with Title 42, Part 2 of the Code of Federal Regulations. Often referred to as 42 CFR Part 2, this is the United States Code of Regulations. It's essentially the federal version of the California State Code of Regulations. And what California is doing here is basically deferring confidentiality regulations and statutes to the United States government. It's saying alcohol and drug counselors need to follow what the US government says you have to follow. So that way they don't come up with their own separate code of regulations regarding confidentiality. Section B3 states the drug and alcohol counselors must cooperate with any complaint investigations and supply information requested during complaint investigations unless that disclosure would compromise client confidentiality as defined by the federal confidentiality rules. Now, this is an important statute here. What essentially it says is that the client is protected from disclosure in an investigation, meaning that you should not say anything about your client that would identify that client in order to protect their confidentiality. However, your colleagues, your coworkers, your peers are not protected. So if the Department of Healthcare Services or one of the certifying organizations is investigating your coworker for an ethical violation and they contact you, if you are a registered or certified alcohol and drug counselor, you're expected to cooperate in the investigation. And due to the fact that this is actually listed in the Code of Regulations, failure to supply information requested during a complaint investigation could ultimately come back on you and launch their own investigation, right? Or potential penalties for failure to do so. So the state's making it clear, if somebody does something that is unethical or illegal and we investigate it, we expect all registered and certified drug and alcohol counselors to cooperate with us in that investigation. Section C1 prohibits drug and alcohol counselors from providing counseling services, attending any program activities, or being on program premises while under the influence of any amount of alcohol or illicit, meaning illegal drugs, as defined by the state. So the state is saying that if you are a registered or certified drug and alcohol counselor, you cannot set foot on program premises or provide any counseling or even attend an outside program activity like a program-sponsored picnic or something like that if you have any amount of alcohol or any other drug in your system. That is a violation of the state minimum requirements for the ethical codes. Now, there are exceptions that are made for over-the-counter or doctor-prescribed medications used in the dosage and frequency prescribed. In other words, if somebody is taking prescribed medication from a doctor and they're using it the way they're supposed to use it, meaning they're not abusing it, that's fine. But otherwise, No drugs and alcohol in the system if you are participating in alcohol and drug counseling activities. Section C2 prohibits providing services beyond the scope of a registered or certified alcohol and drug counselor. That's been covered in a couple of different ways in this presentation, both in the laws and the regulations. So it basically is just, again, an ethical warning to stay in your lane. So as a drug and alcohol counselor, you are trained and able to provide all things related to drug and alcohol counseling, which essentially means that you can talk about anything with a client so long as it relates in some way as to why that person is using or abusing substances, or how things need to be addressed in order to stop that person from using substances in a problematic manner. So a drug and alcohol counselor can definitely talk with a client about mental health related conditions if those mental health related conditions could potentially relate to the substance use disorder. Drug and alcohol counselors are trained to do family counseling in substance use treatment facilities. So if your client is discharging and the client's spouse and adult child come in to do a family relapse prevention planning session, that is well within the scope of practice of a drug and alcohol counselor. What a drug and alcohol counselor cannot do is step outside of that. So they cannot hang up their shingle, and call themselves a marriage therapist. They can certainly talk to a spouse if the discussion is in relation to substance abuse, but they can't just call themselves a marriage counselor. Drug and alcohol counselor can't prescribe medications. Drug and alcohol counselor can't treat schizophrenia, by itself. Again, they can definitely talk with a client about schizophrenia. The addressing of co-occurring disorders is covered in a different course in the City College Alcohol and Other Drug Studies program. So drug and alcohol counselors can absolutely address mental health conditions in the context of a co-occurring disorder or related to substance use, but not treat that independently. Okay, Section C3 prohibits any type of discrimination against clients, residents, or staff members. So as a drug and alcohol counselor, you cannot discriminate against anyone who is even loosely associated with a substance use treatment program or any fellow staff members, or really, nor should there be any discrimination against anybody altogether. And so the phrase including but not limited to means that basically no discrimination, but specifically the state mentions race, religion, gender, disability, national ancestry, sexual orientation, or economic condition. Section C4 prohibits engaging in any social or business relationships with clients or client family members or persons who are significant to clients. Now, there's a couple of ethical codes that have this phrase: clients, their family members, or other persons who are significant to them. So essentially what they're saying with that is that any ethical code that has those three things listed means it applies to not only your client, but everybody that's important to that client. So their family members and other people who are significant to them. So prohibits engaging in any social or business relationships. So the business relationship is pretty straightforward. You cannot hire your clients to work for you. You cannot engage them in multi-level marketing, selling them makeup products and then inviting them to sell it to other people and giving you some kind of a cut. You basically can't have a business relationship with clients. But you also can't have a business relationship with the client's sister, or you cannot have a business relationship with the client's girlfriend or boyfriend or somebody else who is significant to them. This ethical code also prohibits engaging in any social relationships. Now, it often happens where counselors meet clients and they really like those clients as a person, and they think to themselves, oh, I really wish this person was my friend. But in the context of the relationship with them as a client, you are prohibited from engaging in any social relationship. Now, one of the things that has become a big deal in the last 5-10 years is social media. Social media is a type of social relationship. And again, the Code of California Regulations prohibits engaging in any kind of social relationship. So for the most part, that has been interpreted that you should not be Instagram following your clients or them you, or being a Facebook friend, or connecting through LinkedIn. I mean, those social media platforms are a type of social relationship, and the ethical recommendation is just to keep a firewall between you, your client, and significant members to them through all social and business relationships. Section C5 prohibits engaging in any kind of sexual contact with clients, their family members, or any other persons who are significant to the clients. So again, you see that phrase there, and it says any sexual contact. So if an alcohol and drug counselor were to kiss a family member of their client, that's a violation of the ethical code, whether or not the client knows about it. So the repeated emphasis on no sexual contact that you see both in the laws and the regulations and in the ethical codes is in part because there have been numerous sexual violations with alcohol and drug counselors through the years, and other types of mental health and behavioral health counseling clinicians, in which they engage in some kind of sexual contact with clients or significant others. So the state's being very clear and covering all their bases on this. Do not have any sexual contact with any clients or anybody that the client knows or anybody that they're close to. Just take that off the table. That is a violation on multiple levels and will lead to potential loss of registration or certification. All right, section C6 prohibits any verbal, physical, or sexual harassment, which includes threatening or abusing any client, their family members, or any other persons who are significant to them. That's that same phrase again. But note that they also tacked on or any other staff member. So if a drug and alcohol counselor is verbally harassing another staff member and that is reported, that is considered a violation of the state minimum standards for ethical conduct. So this is an interesting one. So in section D, this is a direct quote from the Code of Regulations. It says, quote, "At its discretion, the certifying organization may choose to exclude any convictions for usage or possession of drugs or alcohol which occurred prior to the time of registration for certification as an alcohol and drug counselor as a violation of the Code of Conduct." Now, that is a very funny worded statement. So what the state is essentially acknowledging is that the certifying organizations can deny certification or registration for past drug crimes. And the state is basically saying, well, we're going to leave that decision to the certifying organizations. But they went one step further. They said, at the discretion of the certifying organizations, those certifying organizations may choose to exclude any conviction of possession for drugs or alcohol. Meaning they're saying, hey, if the credentialing organization, the certifying organization doesn't care that you have a charge for drug possession, well, then that's fine. Then they can choose to leave that out if they're going to certify you. Now, what they didn't do is phrase it as the certifying organization may choose to include any convictions as a reason for denying registration or certification as a violation of the Code of Conduct. But by putting this phrase in the Code of Regulations, essentially they are saying that the certifying organization may choose to exclude or include any convictions for usage or possession of drugs and alcohol that occurred prior to the time of registration as a violation of the Code of Conduct, meaning that they can deny you then registration or certification. Now, for the most part, the three certifying organizations in the state of California are pretty good about this. If somebody who is applying for registration or certification has a past drug or alcohol crime on their record, but can show that they have enrolled in an accredited educational training program, they have no new or recent charges, they're doing things right, essentially. That is generally not a condition for denying registration or certification. Okay, and then at the end, note that while the state sets the minimum ethical requirements for counselor conduct, Section F explicitly allows that certifying organizations and AOD programs may impose more stringent standards at their discretion. So what this means is that the certifying organization's ethical codes of conduct must include the state requirements, but they can also add on additional requirements as they see fit. And all three of the certifying organizations in California have additions to their individual ethical codes over and above the state minimums. And note that it's also stating that AOD programs or substance use treatment programs themselves can also impose more stringent ethical standards at their discretion. So if your agency that you're working at decides to set an ethical code, they explicitly say that you cannot be Facebook friends, with a client, and you violate that. What they're doing is they're saying you can't point back to the state and say, well, the state doesn't say anything about Facebook. They're saying, hey, if the AOD program wants to impose more stringent standards, the state is giving them the right to do that. So because of that, it is very important that an alcohol and drug counselor is familiar with their certifying organization's code of conduct, because transgression, which means acting against the ethical code, could mean loss of registration or certification status. So if you have certified with CADAP, then you need to make sure you are very clear with what CADAP's ethical code of conduct states, or with CCAP, or et cetera. This is also important to note, because if you lose your registration or certification status with one certifying organization, it essentially blocks you from registering or certifying with the others pending an appeal of whatever the violation is, because of the laws and regulations that require the certifying organizations to check with each other before they register or certify any new counselor. All right. As we come near the end of our discussion about the rules and regulations in California as it pertains to substance use treatment, there is one other regulatory entity who will definitely impact the lives of alcohol and drug counselors in the state of California. As noted earlier, there are multiple layers of administrative oversight for alcohol and drug counseling activities that impose requirements, create rules or conditions or restrictions, set standards, and enforce compliance or administer penalties for the alcohol and drug counseling profession. And the other entity that has this power are the funders. So a funder is a person or an organization that provides money for a particular purpose. So in the realm of substance use treatment, somebody is paying for the treatment, and the person who's paying for the treatment is the funder. Okay. For those of you who are watching this video as part of a course at San Diego City College that you're receiving credit for, this is the keyword or key phrase non sequitur. You are going to be tested upon the conclusion of this video, and one of the questions will ask for the keyword or the key phrase. This keyword or phrase will not be in the PowerPoint slides, and the student will only know the keyword or phrase if they actually watched the video. So the keyword or phrase for this video is, "It is sunny in Phoenix." That's Phoenix, as in the city in Arizona, spelled P-H-O-E-N-I-X. The key phrase is, "It is sunny in Phoenix." All right, now back to our scheduled programming. So the funder in the room is the person or entity who is paying for the treatment services. There are different types and categories of funders who will pay for substance use treatment in the state of California. So the first one is private pay clients. The private pay client means that the client is paying for the entirety of their own substance use treatment from their own funds. The private pay clients may be able to negotiate directly with the substance use treatment provider for the services that are desired or provided. In other words, they could talk to the treatment facility about a sliding scale, meeting a certain cost based upon income thresholds, petitioning for or requesting a partial scholarship, etc. So the private pay client is the person who is paying for their own treatment. Then there are private PPO health insurance plans that also pay for substance use treatment. So a PPO refers to a preferred provider organization policy. So a PPO plan is purchased by the client, or it is provided to the client through an insurance plan at work. And the PPO plan will pay providers for medical care, including treatment for substance use disorders. So a client can choose their own treatment provider when they have a PPO plan, assuming that that treatment provider takes PPO insurance. So it provides a bit more freedom in terms of choosing who you want to get your treatment with. So there may be 3 different treatment facilities that all seem to be really appealing. And if a person has a PPO health insurance policy, they can potentially make a choice of all 3 of those facilities based simply on factors related to those facilities, not necessarily on whether or not they can pay for it. This, of course, assumes that the treatment facility takes their PPO insurance. So PPO insurance may have deductibles, and that should be usually has deductibles or almost always has deductibles. So these are going to be the portion of the treatment that the client is required to pay for. So examples of PPO insurance companies are Anthem, Blue Cross, Cigna, Molina, insurance plans such as that. There are also private HMO health insurance plans, which will also pay for substance use treatment. And HMO refers to a health maintenance organization. So a health maintenance organization, similar to a PPO plan, a client purchases that insurance plan, or the HMO insurance plan is paid for through work. And the plan then pays for medical care, including substance use disorder treatment. The thing about an HMO plan is that the clients can only receive services from providers who are in a limited network. So unlike in a PPO plan, when the client may be able to choose between 3 providers based upon which one they like the best, if they have an HMO health insurance plan, then they're only going to be able to receive services from certain providers who are in a network with that HMO plan. Typically, HMO plans are cheaper than PPO plans, in part because they limit the possible treatment providers that they can go see. And many times HMO plans have lower deductibles than PPO plans. So examples of HMO plans are Kaiser, Sharp, TRICARE, plans like that in California. Then there is public health insurance. So public health insurance is when the state or some other government-funded entity is providing health insurance programs to pay for medical care for people who qualify. Now, almost all public health insurance organizations have income limits, meaning that they are only available to people in lower income categories or brackets. That if you make too much money, you may not qualify any longer for a public health insurance plan. Like the other health insurance plans, public health insurance plans may have deductibles. Examples of public health insurance plans are California Drug Medi-Cal, the Veteran Affairs Healthcare or VA Healthcare, Children's Health Insurance Program, etc. And then there are grant-funded programs. So grants are funds provided either by a government entity, or an organization, or a private individual that are designated to provide a particular type of service. So in other words, SAMHSA, the Federal Substance Abuse Mental Health Services Administration, periodically releases grants. These grants are typically for treatment providers to provide a certain type of service. So there may be a grant to provide substance use treatment services to individuals who are HIV positive. Or an organization itself may have a grant to provide a certain type of services, or a private individual may fund a particular type of service. Bill Gates, may use a portion of his substantial income to create a grant that provides a service for a certain type of individual or program, et cetera. So there are some substance use treatment programs in California that are funded either partially or entirely through grants. And when a grant is provided, or a grant is funding the services provided, that typically means that individuals will be able to get that service for free or for very low cost. So examples of programs in San Diego who are funded through grants are Father Joe's Villages, Veterans Village of San Diego, Family Health Centers in San Diego also has grants. So there's grant funded programs. And then the other category worth mentioning is free or scholarship services, in which a substance use treatment program provides services to a client without any requirement of payment. Scholarships may be offered on a case-by-case basis where the treatment services provider evaluates an individual's qualifications for a scholarship, or it's only available if an individual requests a scholarship. But sometimes treatment providers will also designate a certain number of scholarships per month or per year that they will offer out to the public for people that otherwise couldn't afford substance use treatment. So a scholarship service may ask for a donation. So it's a scholarship, but the client has the ability to donate some money towards the scholarship. And scholarships may include bartering for services, which is an exchange of goods or services in exchange for treatment. Now, bartering in California is not illegal, but it could potentially introduce ethical dilemmas. For example, a substance use treatment program may barter for cleaning services. An individual who provides cleaning services after hours is able to receive substance use treatment services during the day for free or for donation. But at the same time, the person providing the cleaning has access potentially to offices or maybe even files that they shouldn't otherwise have access to. So bartering is, again, not illegal, but something to be done with great caution because of the potential ethical dilemmas. Okay, and to conclude, we'll just talk about funder rules and regulations. So funders are not a regulatory agency, not strictly anyway. A regulatory agency is an independent governmental body established by legislative act in order to set standards in a specific field of activity. The Department of Healthcare Services is a regulatory agency. As we discussed earlier, that is an independent governmental body that was established by the legislature. So funders are not a regulatory agency, but funders have significant regulatory power, meaning their ability to set rules if the providers want to get paid from those funders. In the United States, in general, funders have been given a lot of freedom when it comes to setting the conditions or requirements that must be met in order to get paid for services. It sort of looks like this. If I'm the one that's funding the services, I say, great, I will pay for these services if you use a certain form for all of your intakes, or if you provide only these types of services. And the way that works is if you don't want to do that, then me as the funder, I simply say, okay, you don't have to. But if you don't do that, then I'm not paying. And so they can create an enormous amount of pressure on substance use treatment facilities in order to get paid for their services. And it's notable that the California state laws and regulations are mostly silent about payment for substance use treatment services, meaning that they simply don't talk about it, in which case there is no law in place dictating what's legal or illegal when it comes to funding in general. And there definitely is an exception with regards to California Drug Medi-Cal, the public health insurance funding program for substance use treatment that is regulated by the state. There are a number of statements in the laws and the regulations about Drug Medi-Cal, but not so much about private funding or grant funding. And so this essentially means that funders are often able to act without regulatory limits in establishing stipulations that must be met before payment. So a funder is allowed with some limitations to set specific guidelines, expectations, parameters, requirements before agreeing to pay for services, like setting a limit on the number of sessions or the number of days that they're willing to pay for. They may require particular types of services and reject other types of services, meaning that the funder may say that art therapy is not an evidence-based practice, and thus we will not pay for any art therapy sessions. Or equine therapy, which is the use of horses in therapies. Oftentimes in trauma types of therapies, the funder may say they're not going to pay for equine therapy. They're only going to pay for relapse prevention services, something like that. The funders may require the use of certain types of forms that in order to get paid for a session, you must use an approved form. And if you turn in any other kind of form, then they're not going to pay for whatever that session was. They may require ongoing chart utilization reviews before agreeing to continue to pay. So a chart utilization review, we'll talk about it a little more in just a second, is basically a scheduled review of the chart, the services, the progress that the client is making before they'll agree to pay past that. So we'll give you 5 days of funding, and then there needs to be an additional chart utilization review before we agree to pay anything further. And a myriad of other rules and regulations that funders can come up with. Now, generally, funders cannot supersede or contradict laws, rules, or regulations that are set by the states or the federal government. So if there is a legal or regulatory contradiction, funders can be sued in civil or criminal courts, just like individuals, and or investigated by government legislative entities. For example, if the funder says, hey, you got to pay me $1,000 for every client before I'll agree to pay for any services, that would be illegal. And in that case, the funders could be sued in court. But again, for the most part, funders have a fair amount of leeway when it comes to setting rules and regulations for what they're willing to pay for and how you're going to get paid. Now, although funder requirements are more targeted towards the substance use treatment facilities themselves, meaning not the counselors, but these are the rules that the treatment facility has to follow. A lot of times referencing billing reimbursement, so how the treatment agency gets paid. These funder regulations are ultimately going to impact the day-to-day work of the alcohol and drug counselor as well. They will essentially dictate what you must or cannot do. Again, you having to use certain forms or only providing certain types of services. There are often pressures that drug and alcohol counselors feel to provide services that are billable. If an intake assessment, is paid for with a ratio of 3 hours of service, meaning that it should take an intake assessment 3 hours, then the counselor may feel pressure if they have a really talkative client to get that done within the 3-hour window because they're not going to get paid for anything past the 3 hours. And so their supervisor may say, you must get this done within 3 hours because that's what insurance requires. Counselors are also often interacting with insurance companies through case or utilization reviews. Most substance use treatment facilities in California have the alcohol and drug counselor do the utilization reviews rather than someone else, because they're the ones that have the most knowledge about the client's treatment. So whatever the funder rules and regulations are, they will definitely impact the day-to-day work of an alcohol and drug counselor. Again, we had mentioned earlier the utilization reviews. So the utilization review is a formal process of reviewing the treatment services that are being provided to the client. These are sometimes referred to as episodes of care. So if a client is in an intensive outpatient program and they are receiving 2 groups a day, 5 days a week, and they are receiving 1 individual recovery counseling session per week, those would be episodes of care. And so the person, the funder, the entity who's paying for it, may require a process of reviewing those services. So you go 1 week and then there is a utilization review. We need to review what was offered, what was happened, is the client making progress, et cetera. Again, this is often conducted by the treatment provider, which is usually the alcohol and drug counselor, and then reviewed by the funder to determine if the funder is going to provide payment for further treatment services. So you have 1 week, 2 groups a day, 5 days a week, you've got 10 groups, you had 1 session. The funder may say, okay, we're not paying anything past that until we do a review of the chart. Were these services actually offered? how long did these services take, what was actually done in those services, did the client show up or not show up, did they make progress, et cetera. And the funder will need to look at this review before they'll agree to pay for anything further. Now, utilization reviews can be really frustrating. In my personal experience of utilization reviews, everybody gets frustrated on the clinical side or the provider side, because typically the clinical team wants to provide as many services as necessary in order to support recovery, but the funder typically wants to pay as little as possible and may argue that services are unnecessary. So the process of the utilization review also includes basically making a case, presenting what the client's treatment needs are, making statements about what the recommended services are for the particular condition that the client is presenting, and then evaluating the client's progress, basically what they've done up to this point and how much more services are needed. Now, utilization reviews require speaking the funder's language. Very few insurance case managers are clinically trained. So trying to appeal to them, by using clinical language typically isn't going to work. So the person doing the utilization review needs to justify medical necessity using the funder's language. And what that means is that the client must be shown to need the services being provided or the recommended services, and often you need to show that they cannot get those services elsewhere or in a less expensive option. And the client must be making progress. So that's tricky, right? So if the client's showing too much progress, well, then the funder may decide there's no longer medical necessity, right? The client seems like they're doing good. We don't need to pay anymore. But if they're making no progress, then the funder may say, well, this person's obviously not getting out of this what they need to, or they're not participating appropriately, or you're not delivering it correctly, and so we're not going to pay for that either. So the delicate balance is they need these services and they're making progress. So again, utilization reviews, typically not fun for the clinician doing those reviews. Now, note that a funder can ask for a utilization review at any time, and they may only fund a small amount before requiring another utilization review. I personally have had this experience where a funder has only paid for 3 more days, and then they require another utilization review before they're going to pay something further. They have the right to do that. The state essentially gives them the leeway. So the bottom line is, if you want a funder to pay, you're going to have to play by their rules and their decisions. Now, it's notable that most funders have a system where a client or a medical care organization can appeal or request a review of a decision made by a funder to stop paying for services. So if you do a utilization review, the funder comes back and says, okay, we think they're good. They don't need these services anymore. Your treatment facility will have the ability, in most cases, to appeal that and say, I'd like that to be reviewed. And sometimes it gets bumped up the lines then. There may be, the utilization review may be done via paper, that it's typed out and sent to the funder. And when you do an appeal, there might have to be a face-to-face appeal, a meeting of some sort that is scheduled where it's talked out. Sometimes there are doctor-to-doctor peer reviews. So it may require the clinical director or the medical director to get on the phone with a doctor who's being employed by the funder in order to essentially have an argument about whether they're going to pay for that or not. All right, so that takes us to the end of a very long process through part 1, 2, 3, and 4 about the rules and regulations for substance use treatment and alcohol and drug counselors in the state of California. So in closing, I will mention once again that this introductory presentation does not cover all the laws, regulations, and ethical codes that you need to follow as an alcohol and drug counselor. We did cover a lot and a good foundation, but you will not be able to use this PowerPoint for all the rules, regulations, and codes that you need to follow. Please consult with supervisors, lawyers, ethical boards, and funders whenever there is any doubt, and follow the basic rules.